Hello and welcome to the Thundering 36. My name is Tyler. I serve as chair, and we are very excited to have Jaime Hawk here today to speak about her candidacy for the Washington State Supreme Court. Over to you, Jaime, to introduce yourself and welcome.
Good afternoon, all. It's great to be with you today. I am Judge Jaime Hawk. I'm running for the Washington Supreme Court Position 3, one of the two open seats. And as a Supreme Court Justice, I will protect your rights and freedoms and the rule of law. I want to start by telling you a little about myself and what has brought me here. I was raised by a single mom, attended public schools, and I'm the first in my immediate family to go to college. After graduating from Gonzaga, I worked as an advocate for domestic violence and sexual assault victims. Then I went to law school on a public interest scholarship. After graduating from law school, I began my legal career as an attorney fellow, working with the U.S. Senate Judiciary Committee staff for Senator Ted Kennedy in D.C. And while working in that capacity, I got to meet and work with then little known Professor Elizabeth Warren on a bankruptcy bill that deepened my understanding of economic justice issues. I returned to our Washington to work on a juvenile justice reform project as a public defender. Then I became a federal public defender and in the courtroom protected the constitutional rights of people facing the full power of the federal government, including immigrants being imprisoned and separated from their families by ICE agents. I then did civil rights work at the ACLU of Washington, where I was the legal strategy director for Smart Justice, working on statewide criminal legal system reform to address mass incarceration and racial disparities. I was the first lawyer at the ACLU of Washington to become a judge in our state, and I was appointed by Governor Inslee to King County Superior Court, where I preside over a broad range of civil, criminal, and family law cases. I strive every day to ensure the promise of equal justice and access to justice is realized.
Thank you so much. Over to you, Nita.
First question, how would you approach cases asking to overturn long-standing judicial precedents, especially for cases that were decided a long time ago when Washington State looked differently than it does now?
Thank you for that question. Respect for precedent, or what we call stare decisis, is a cornerstone of the rule of law. People rely on the stability of court decisions, and that stability promotes predictability and reliability, which is important for us to have. We have seen nationally when the Dobbs decision was overturned, Roe v. Wade, by the U.S. Supreme Court, how destabilizing that can be for trust and public confidence in the courts and in our judiciary. But that said, precedent is never absolute. And when a prior decision is clearly wrong or unworkable or inconsistent with constitutional or statutory principles, courts must re-examine it. And so my approach is thoughtful and cautious. I would look at factors like the quality of the original reasoning of the court, whether the rule has proven to be workable, whether there's legal or factual developments that have undermined the decision. And ultimately, my job is not to preserve precedent nor overturn it lightly. It is to faithfully interpret the law and Constitution as written, to really maintain and promote public trust and confidence. One area quickly where one analysis is really looking at harmful outcomes, and I've been really proud of how our Supreme Court has really tackled after the 2020 letter, focusing on how the courts have been complicit in racism or anti-Black racism. They've found specific cases with that harmful or racist outcome that have been overturned.
Thank you. Will?
Yes, Judge Hawk, artificial intelligence or AI is not always a well-defined or understood term. How would you define AI and how would you think the court should approach it in day-to-day operations?
I define AI as simply tools that use data and algorithms to assist or automate decision making. But I think there's much more to its implications than that. Our King County Superior Court just adopted an AI governance and use policy. And we're struggling with it and learning as we go, and just really trying to have protocols and clear policy in place. But I expect in the years ahead in the court system, there'll be opportunities for greater administrative efficiency. Potentially, I think about areas like scheduling or providing greater public assistance to court information or other general management type tools. But we must understand the ethical transparency and other limits of AI in the courts. AI must never replace judicial judgment and discretion, which is something that our King County policy that we just adopted it really emphasizes. And confidential data must also be preserved. So decisions that affect people's rights, liberty, and livelihoods must remain human decisions grounded in law and reason and accountability. So I see a greater use of AI daily in courts by unrepresented litigants in my courtroom. So I'm currently managing family law cases and trials, and I'm seeing a lot of chat GPT, and I can usually tell because there's little bullets and how it's presented, but it's creating some ethical questions and concern for those involved in the cases, in large part because the cases aren't factually correct. There's hallucinations, things like that, and the cases cited don't actually represent the law. And so, but we're working through many of those things.
Thank you. Anita?
The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds with a distinctly different path to clerk for liberal versus conservative federal judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is inherently a political endeavor, how do we ensure that judicial races do not become de facto partisan?
Thank you for that question. I was not aware of that, and thank you for alerting me to it. It's quite concerning. But a good law clerk should not have a partisan alignment. I clerked for a federal judge in Yakima and understand the importance of interpersonal alignment. I was familiar with his background and his leadership with the Bar Association, for example, but and his work on access to justice issues. But that does not require an ideological alignment. In fact, I think that's quite concerning and limiting for our law students and young lawyers. While judges and law clerks are, of course, human, my experience of clerks that I know and had worked with previously, many have clerked for judges of different ideological backgrounds. We need to make sure that there are no echo chambers, in that literal sense. Teams are always stronger with diverse viewpoints and life experience. It leads to better analysis, better decision making. And as for maintaining a nonpartisan bench, especially in an elected system, it starts with how judges conduct themselves. We have to be disciplined about not signaling outcomes, not making promises, or how we would view or decide a particular case, and being independent and neutral. Our state judicial canons provide clear guidance on how to maintain this practice. And it's something I strive to do every day with all matters before me. Despite having unique work experience myself in civil rights and public defense, that I believe provide valuable perspective on the bench, but that is different than being aligned in any partisan way.
Thank you. We'll ask our last prepared question.
Thank you. Could you tell us a little bit about the continuing education requirement for judges? How do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? And how have you applied these to your work?
Thank you. So lawyers have CLEs, continuing legal education credits. They have to report every certain number of years. Judges, we don't have to report quite in the same way, but it's so important. We're lifelong learners, have to continue to keep learning. Every day. Every day we learn new things. So I serve on our Supreme Court Minority and Justice Commission. And I also co-chair for Superior Court, our Courts and Community Committee, which is essentially our external DEI committee. We put on regular trainings and educational programs every month or so for African American History Month, AAPI Month, Native American Heritage Month. We're constantly looking outside the court to bring in speakers, community leaders, and partners that we can learn from. And it's really important to me that we get judges out into the community, connecting with the communities that we serve, learning from them, identifying barriers that folks may be facing, and all the ways that we can expand access to justice. So, and then with the Minority and Justice Commission, I help put on a symposium every year for the Supreme Court justices. I've done I've been on the planning committee for a pretrial and bail reform symposium, one looking at mass incarceration of women and women of color and girls throughout the system and some of the drivers of increasing numbers that we're seeing, one on legal financial obligations, those fines and fees that make things difficult for folks, and then on jury diversity. I was able to work with some attorneys and find a juror that had been excluded from a jury based on her comments to some of the questions. And she was a woman of color, felt sort of discriminated against. And I was able to find her. She was working at Starbucks, and bring her to the Supreme Court in Olympia. She testified, shared her story. And this was right before the court adopted GR 37, which is an important rule to identify race bias in jury selection. So those are just some of the ways that I've been heavily involved with education and continue to learn myself.
Thank you. We'll go to follow-up questions from our board. Sarah, over to you. These will have 1 minute for responses.
Thank you. Can you tell us a little about your experience handling appeals in the state and federal court, either as a law clerk, advocate, or whatever capacity you've handled them, and how that experience would inform your perspective and approach on the highest court?
Thank you. Yes. So my appellate experience as a lawyer, obviously, I mentioned I clerked for a federal judge who's a trial judge, and then both as a federal public defender and with the ACLU. As a federal defender, I had some Ninth Circuit appeals that I worked on, and I argued one before the Ninth Circuit. And then as an ACLU attorney, dealing with issues of state constitutional law, particularly around racial disparity and disproportionality that exists at every stage of the criminal legal system. We work together with collaborating attorneys, the Korematsu Center at SU Law, and other groups to litigate several appellate issues through amicus briefs. And then I also had a case. We sued the state of Washington, and we had an appeal up to the Washington Supreme Court. So that work and those experiences in terms of protecting our constitutional rights and liberties and the Washington state constitution are incredibly valuable, and I bring with me to the court as a justice.
Thank you. Are there more follow-up questions? Anita, Will? Sarah, do you have another one?
I don't think so. Thank you,
Okay.
though.
I'm going to put you, though, Will, as a law student on the spot for even if it's like career advice or anything out of the box. And then we'll go to the closing 90 seconds, Jamie. But Will, I am going to put you on the spot as a law student to ask a question. Go for it.
All good. And I guess going back to the nonpartisan thing, I know it's sort of difficult. I mean, you work with Ted Kennedy, and I'm working with the Democrats. I don't know. How do you sort of to gauge the the desire you have to be nonpartisan as part of your job, your career as a lawyer, and then also your personal political beliefs and your personal work in politics. Aside from that, like how do you balance that? How do you balance that throughout your career?
Great question. So, it's obviously we have our track records, decisions that we've made, work that we've done. We have our values as individuals and the cases that we've worked on. And the reality of elections are such that, like I'm here today seeking a, endorsement. But, as I mentioned, the judicial canons and all the rules that we have, it's so incredibly important. We have an independent judiciary. We have judges that have their own backgrounds and views and values and experiences, but are dedicated to a strong, independent judiciary that is impartial and just looks at every case and works hard to apply the facts in front of the court to the law, apply the law to the facts. So I'm sorry, I wish I had more time to answer that, but I hope that was at least a initial response.
No, that was useful. Thank you.
Thank you so much, Jamie. So we invite you now to just share whatever you would like to share with us in closing. Over to you.
Thank
And
you
you can
so
take a little, you can run a little bit beyond our 90 seconds. Since we didn't do a final follow-up question, feel free to give us, closer to 2 minutes or so if you wish.
Excellent. Thank you so much. I appreciate that. So, I want to thank you all, of course, for your time volunteering for this important process. I know it's busy and it's beautiful outside, and I just appreciate you spending the day doing this. Elections for our Supreme Court justices have never been more important than in this moment. Of the 6 candidates running for the 2 open seats, I'm the only woman running, and my race for position 3 will likely determine whether we maintain a female majority on our Washington Supreme Court. I believe there's a clear contrast in this race. My entire legal career has been defined by advocating for those most marginalized and those who lack power and resources. As lawyers, we make choices about where we work and the type of work that we do, and looking at that track record is very important. Our legal experience tells a story, and you need to determine what work aligns with your values. I have never worked for a corporate law firm. I have never defended the federal government. I've spent my legal career protecting the constitutional rights of individual Washingtonians and serving the public interest over the last 25 years since I became a law student. And as a King County Superior Court judge, I defend your rights and freedoms and the rule of law every day in court, and will continue to do so on the Supreme Court. I'm endorsed by over 100 current and retired judges in 28 counties across the state, and I am pleased to be the only candidate who is solely endorsed by Governor Ferguson. And so far, just a couple days ago, I earned my first being a candidate recommended for a county labor organization endorsement. And I'm represented by several other state electeds, including Senator Noelle Frame, which I'm very proud to have her endorsement, Vanna Slaughter, Tina Orwell, Representative Nicole Macri, April Berg, among others in this race. And I would be very honored to have your endorsement as well. And just again, really appreciate all your hard work and your time through this process. Oh, and I hope to see many of you. I think it's Thursday this week at the 36th, the candidate forum. So, or the event. So at Rough and Tumble, I hope to be there and see you all, many of you then.
Thank you so much. This ends the formal part of our interview, so we'll stop recording.